The next step in understanding the Australian legal system is to look at how we classify law. We're going to look at this in multiple levels. First, we're going to look at the different systems of law that can operate in the world. Then we're going to concentrate on the common law system that we have in Australia and look at different classifications or different ways of saying what a law is actually about. The first classification system that we want to look at is the national system of law that can be in place in a country. So what we have here is a diagram that sets out the different ways that we might classify law, including the multiple uses of common law. So I'm going to spend a bit of time on this diagram and then go over the slides reasonably quickly to reiterate and explain in a bit more detail with a little bit more explanation of some of these classification systems. At the first level, when we say common law, what we're dealing with is the national system of law in a country. And there are different kinds of legal system a country can have. Sino-Soviet systems, so communistic systems here. We could have systems based upon religion, Islamic, Hindu, Talmudic systems of law. The two core systems of law that are throughout much of the world are either a common law system or a civil law system. The common law system is the Anglo system that developed via Britain, and the civil law system developed through continental Europe. And it particularly was influenced by both Roman law and Napoleon and the French and the Napoleonic Code. Okay, they've had heavily influenced. We'll come back to that. Now, within the British common law system, you can actually see that we have two kinds of law. The first is statute, right? And that's the law that Parliament makes. Okay, so our parliamentarians make this law. But we also have judge-made law. Okay, so originally, the law was made by the judge or the monarch, the king or queen, right? And so the common law system originally meant judge-made law, but now we have statute as well, and we'll go into that development in a minute. So when we use the word common law, we can either mean the entire Anglo system, which is both legislation and judge-made law, or depending upon how it's used, we could just be talking about judge-made law. To make it even more confusing, within judge-made law, there were originally different courts, the courts of equity, the general common law courts, the courts of admiralty, etc. So there were all these different courts. And common law was a specific type of judge-made law that operates in the Anglo system. Okay, so common law can have those three meanings. The overarching British Anglo system of common law, that's legislation and judge-made law. The specific judge-made law, or a particular kind of judge-made law. We'll come back to that. Okay, so we've got the national system, we've got these three senses of common law, but there are multiple other ways we can classify law. So we can talk about the difference between criminal law and civil law. So criminal law is obviously to do with crimes, and civil law is about either the relationship between people, or it can be the state and people. But really what we're not going to do in civil law is we're not going to throw them in jail, right? Okay, so the penalty element is important. That has important implications for things like the standard of proof and how judges interpret and apply the law can vary. That's why the classification system becomes important. So let's summarize. Law operates within a legal system. Countries have different legal systems. We can organize those various legal systems. Very broadly, the two core legal systems are the common law systems, which is the one in Australia, or the civil law systems, which developed out of continental Europe. This particular diagram gives you a bit of context about the development of the common law system and how we've ended up where we have. Originally, there was customary law administered by local courts, right? So it was varied by the village. With the conquest of England by William the Duke of Normandy, there was a significant change. One of the things that he starts to do is appoint justices, and they go around the country, right? So what he starts developing is a common law based on what the judges decide. He has the same judges deciding things. So we move from variation at the village level to common law via the judges. That gets expanded where judges go on circuit, so they would ride around the countryside, so we have the same judges in different villages, and judges still do this. Okay, so the Supreme Court travels to different cities in Queensland to make sure that the judgments are consistent, and they start recording those decisions, and they start following each other's decisions, the doctrine of precedent, which we'll come to later. Now, around this time, a little bit later, we start to see people questioning the absolute power of the monarch, right? So for the first time, we have a shift from a person to the law. Okay, so we shift from a monarch making decisions to the law being important. And we start to introduce the idea of statute, okay, of law being more important than the whims of a monarch. Now, what's also happening is common law is becoming increasingly inflexible, and so people are coming to the king to try and figure out, can I get a better just outcome? And as a result, we set up the monarch set up the courts of chancery, which administers equity, okay, which relaxed the harsh common law rule, the harsh judge-made law rule. We then move to having a parliament introduced, the crown becomes more of a figurehead, so statute starts to become predominant, and we get equity and common law fused into the single court. So what we end up with is two sources of law. The courts, which are now fused between equity and common law, and statute. Because of the principles here, no individual should have power. We have this idea of Parliament making the law. When we have judge-made law, it's like an individual making the law as a judge. So if there's ever a conflict between a statute and judge-made law, statute prevails because it's said to be the will of the people. So common law systems are based upon the British legal system. There are two sources of law: legislation or statute, and case law or judge-made law. The judiciary is powerful and influential in common law. The courts use an adversarial system. That means the two parties to a case argue. The judge is meant to be impartial and just listens and decides. Okay, it's an important point, important difference to civil law systems. And we see these systems in the UK, Australia, Canada, New Zealand, anywhere that you kind of had the British Empire, you'll see a common law system. Civil law systems are codified law, so they're really statutes or legislation. We can call them codes or constitutions, etc., but they're a form of written law. Case law, you really don't record and isn't recognised, so it's not a source of law. That developed from the Roman model, and as I said before, the Napoleonic Code had a huge influence there as well. Courts under a civil law system use an inquisitorial system. That means the judge is actively trying to find the truth. And that's a really big difference. It's not the parties arguing with the judge being impartial, it's the judge trying to find the truth. And we see this in many countries. Of course, we see it in continental Europe, but we also see it in countries where those particular powers colonised during the 16th to 18th, 19th century, etc. And so we see this historical implementation of these two different legal systems throughout most of the world.